So, good morning. I'm so happy to see you all either here now in real time or live in the replay. Today, we're going to talk about an issue that's very important to so many people with repetitive strain injury. And we're going to have as our guest Jon Gelman, who's a leading light in the area of workers' compensation. He's written two books about it, and he can tell you a little bit more about himself.
Let's talk about this generally. First of all, I'm not going to praise myself. You could look up my CV online at that site. But let's really get down to the grips of this, which is the nitty gritty of repetitive stress injuries and workers' compensation. Most of you out there have never been involved in workers' compensation, so it's your first time at the rodeo if you get injured at work. Another caveat I would like to give you is that this is a general conversation about workers' compensation, and there are so many jurisdictional issues that you'll need to consult an expert, which is an attorney at law in the field in your jurisdiction. Okay, so I'm just going to give you an overall covering what the whole system's about, so you're more comfortable with it and you're more aware of it. And I know when you have your stress injury, the first thing you're going to have is discomfort and pain and disorientation, and you're going to meet a whole lot of people that you've never met before, and you're going to develop new relationships with medical providers and insurance companies and insurance adjusters and lawyers, and it's a whole new arena. But you need to have a knowledge of the overall aspect of this so that you can go in there with an awareness as to what you should be doing. So let's go back and talk about, next slide, is how workers' compensation came about. Workers' compensation is a social remedial legislation process. It's not an actual trial before a judge and a jury. It's an administrative procedure where you go before an administrative officer. And it's under the executive branch in New Jersey, which is probably common in all jurisdictions. In 1911, in Europe, they enacted social legislation. Europe is way, way ahead of where the United States is and should be on dealing with work related injuries. Their medical delivery system is entirely different. They don't make you go through this excruciating process of filing a claim and litigating it out. So in 1911 in New York City, there was a factory called the Triangle Shirtwaist Factory. And it's a sweatshop. And what they did was lock the doors. And so they had more people than they could get out the exits if they were open in time. Well, they had a fire in 1911 in New York, and people were like the 9/11 tragedy, horrific tragedy. These people were just jumping out of the windows to save themselves. So there were approximately 1,946 people who were killed in that fire, and that generated a labor safety movement where the unions, in an organized fashion, put pressure on both the government and the employers to create a system that is summary, meaning fast, easy, and very little expense for claimants or injured workers to file in order to get a recovery. The workers' compensation system in the United States and in all the jurisdictions, and we'll talk about that in a second, the acts are based upon the Model European Act. And the Model European Act took away your right to have a jury. And it took away the defense of contributory negligence. And so if the accident, it's a no fault system. It only has to arise out of and in the course of the employment, the event, and then you could file a claim. Unfortunately, this was 1911. Scientific research was very shallow. There was very little of it, and occupational diseases were not included in the original 1911 Act. That changed moving going forward. What they did was slowly, after the decades moved on, they brought in occupational diseases, and they only brought them in because employers didn't want to get sued for liability from people being exposed occupationally to silica dust, which is sort of what you have with asbestos related disease. And as a result of that, they took that out of the civil system and they moved it into workers' comp, and workers' compensation systems started to include this into the process. And if we look at the next slide, we have a system across the country of multiple jurisdictions. It's a patchwork, just like the map. It's a patchwork of multiple workers' compensation systems that are state directed. Are they uniform? No. Are the laws the same? Requirements to follow? No. Are the recoveries the same? No. Is it chaos? Yes. In some instances, people will select what forum they could go to based upon whether they have extraterritorial jurisdiction, they work in one place and they live in another place. The rules are inconsistent across the entire spectrum, which creates havoc for workers. But if you do, you have to become familiar with your specific state, and that's why you need somebody who's familiar with it. Next slide. Now, occupational disease claims are claims that happen over a long period of time. They may have happened a long time ago, or they may have happened over several months ago, but they didn't happen on one specific day or at one specific moment of that day. And they are difficult to defend for employers and insurance companies because they're not with you 24/7. They're not with you all day long at work, even though they may have you under camera surveillance. Okay? It's just impossible to defend these claims very easily as to whether or not you were performing the activity. The activity has to happen arising out of and in the course of your employment. Those are words, legal terminology that have had interpretations by all 50 jurisdictions in every which way. The work activity that you perform must be medically linked to the resulting occupational disease. And that is what we call causal relationship. And that's another hurdle that you have to go over in the proof of your case. Even though it happened on the job, you have to prove that it was causally related to the task or effort or work that you did specifically. Okay, let's go to the next slide. I've been asked this a lot of times. Why can't we sue somebody else? Why can't we sue the person who makes the keyboard? Why can't we sue the person who makes the mouse? Why my hand hurts when I use it? Why can't I sue him? My chair is in the wrong spot. My arms hurt. My legs hurt. Why can't we sue the manufacturers of the chairs, the tables, the keyboards, all of these instruments? Those are the ultimate third party claims. They're the ultimate third party wrongdoers. And you can file a case against them. And that would be a civil action. So you could go after the manufacturers, distributors, or research groups who designed the mouse or the keyboard or anything else, except you're now in the arena of a civil litigation and before a jury, and there's different rules that apply in every jurisdiction. And those rules include the defense of contributory negligence. And your workers' compensation insurance company would like you to sue an ultimate wrongdoer because in most jurisdictions, they get 100% reimbursed for any money they pay out because it wasn't their fault. Unfortunately, the third party claims are near impossible to prove. We are so far down the road on this topic already that the manufacturers, distributors, and research groups have actually taken all the precautions necessary that you would think, but in reality, sometimes there aren't enough. So your only resort is going to be back in the workers' compensation system. The third party claims give you an unscheduled amount of recovery so you could sue for what we call punitive damages to punish these people. However, they're smart enough and they're wise enough now that they've protected themselves through all kinds of things, including approvals by governmental organizations or warnings on every piece of thing that you touch that goes on. The warnings go on and on. The little extra piece of paper they throw in everything, they just go on and on and on. So you have to go back to basically file a workers' compensation claim. So let's go into one of the benefits you're entitled to under workers' compensation, which is the next slide, which is medical treatment. You're going to wonder, you're hurt, you don't know what to do, you want to go to your own doctor, you want to go to the doc in the emergent medical down the street in the shopping center, but you don't know if that's going to be paid for by the workers' compensation carrier. In certain jurisdictions, the employer even selects the physician who could treat you. And it is further compounded, even if you have the option, the insurance company may deny your treatment. And then you have to seek unauthorized medical care and go after the physician. And Deborah and I were talking about this before the seminar this morning, that in many cases, the window of treatment closes. So you have to act pretty quickly in taking care of yourself. So it's you who is important and they work out the reimbursement of it later. The problem is that the first thing the receptionist asks you when you call up for an appointment is, one, do you have an insurance? Do you have insurance? Two, did this happen at work? And if it happened at work, they don't know there's a whole different prescribed, state regulated formula for getting care. And so that's a major issue, and you need to get guidance on it. There are motions that you could file for medical treatment.
This is a really bad problem with repetitive strain injury because most people don't even know they're injured. By the time they're injured, they're already in the latter stages of RSI where it's very difficult to get normal use of the hands back. And so many people have told me that their insurer put off, they would only give them 6 physical therapy sessions. They would deny that it was work related. They would, it's just a mess. But go ahead, Jon.
Even if you're under the Medicare system, they have something that was enacted in November of 1980, if my memory serves correct, which is the Medicare Secondary Payer Act. Now, Medicare may pay, but they're going to go back and say, we shouldn't have paid, and you go get it from your workers' compensation carrier, because the next time you showed up for a problem, we're going to come up with a red screen in the provider's office, stop, no payment. So for your other condition. So that's why one of the forms that you're probably filling out every time you see a physician is the Medicare Secondary Payer Questionnaire. Did this come from the coal mines? Did this come from federal pension? Did this come from state pension? Or did this come from a work-related event? Because Medicare is going to come back and make payment, not only for that, for any future medical care you have. And it is a major, major problem. And that is another reason why coordinating 50 states is rather difficult. However, since 2001, July of 2001, Medicare has ramped up the recovery of their funds, and they have a very sophisticated system. They are they don't operationalize anything. They give it out to contractors. So you're not dealing with somebody in a cubicle in Baltimore. You're dealing with the contractor who has your jurisdiction in the United States, your region, who is covering this problem. And it'll give you great difficulty in settling any case in workers' compensation unless the payment is paid back if it's submitted and if future payments are not covered. And they may even have you set up a Medicare set aside trust to pay for it for the future.
I don't want to derail your presentation, but at some point, I'd like to ask you about the studies because I don't believe that repetitive strain injury has been properly studied. Because there is, if you know what you're doing, you can relate the injury to the job activity. But to my knowledge, nobody has done a systematic analysis of the postures, the amount of time that people are using, the technique that they're using. And if this were studied, I think it would be a whole lot easier to prove causality at work because it's not picking up your kids. I mean, I had one student who said, they tried to say it was from me picking up my kids. That's why I got injured. I wasn't picking up my kids for 8-hour days. I was working at my computer. And so that's the kind of thing where I feel like, it sounds really nice, we've made this compromise, but basically it doesn't serve the worker. And because of the way it's set up, it's so hard to get treated. It's actually a disservice to the people it should be helping. But please
It's a
continue.
difficult process, and the payments are not adequate. Go I'll to your two slides ahead of me. Go to the next slide, which is the sample schedule of rates. Um, well, you're entitled to three types of benefits: temporary disability while you're out of work and under authorized medical care. So you're going to need a doctor to relate in order to do that. You may pull up state disability or short term disability, but they're going to come back as soon as you check off work related or questionable. Permanent disability could be partial in nature, and permanent disability could be total in nature. And these are also works of art that fit into the schedule of disability because they cap how much money you could receive. It's not an endless pot. If we go to the next chart, you'll see that most states rate a percentage of your body with a percentage to dollars. And the rates, these are the 2023 rates. And just to give you an idea, it's based on the state average weekly wage for the year before, which was $1,508 in New Jersey, giving you a maximum payment rate of $1,131.31 for temporary disability and for permanent total. But permanent total never reaches that level unless you're totally disabled, which is another set of complications. So the money that you're receiving, even though it's not federally included in your federal income tax, it's still pretty shy. And they're only paying you 70% of your wages because they figure you're in the 30% bracket. And most people who get injured are not in the 30% bracket. That may be the CEO of the company, but it's not the rest of the people. The people who are doing the grunt work out there don't come close to it. So the rates look good on paper, but they're really inadequate. And they change from jurisdiction to jurisdiction. So these are average rates. The National Commission in 1970 said they should have uniform rates and they should have a better system, but they never got their act together. That was a congressional report under President Nixon, the Republican administration, who established OSHA.
One of the things that people often say about people who are on workers' compensation is, oh, you're just malingering, you just want the money. And, if you're making $100,000, $200,000 a year, what I don't think you're going to get reimbursed at that kind of rate. And even if you're making, $70,000 a year or something like that, who can live on $200 a month or whatever they're getting? I mean,
It's
it just
almost like
doesn't
the
make
poverty level we're dealing with here. It's inadequate. There's no supplemental benefits for it that are easy to come by. And so you have to be out for a while, like 6 months before like Social Security will kick in, and they don't pay for unless they retroactively pay after 2 years. So they'll delay payment. So you'll never fit into that process. If you can get the workers' compensation carrier to pay, that's lovely. Voluntarily, that's a home run. Except if we go to the next slide, the insurance company's in the business of not paying out the claims.
I love
So
that. That should be the license plate or the
it's
quote.
no pay. Their license plate is no pay.
Yeah.
So the the trick is how long could they delay the case and deny the case? And if they delay the case, the money's in their pocket. And what they're in the business of is taking those premium dollars and investing it. They're investing in stocks and real estate and other things. 20% of the United States financial backbone is the insurance business. So they just take this money and they try to hold on to it, and they'll set up a reserve for the case, but they don't have to pay that out until the actual case is either settled or disposed of in court. And the longer they can keep the ball up in the air and bouncing, they're ahead of the game. So the longer that they could avoid paying an occupational disease claim or any case, they're winning the game. And that's their modus operandi, period, end. I mean, you'll have some insurance companies who will insure the top 50 companies in the United States, and they have a better understanding of trying to get the person back to work so that the employer will have a skilled person there.
Hello. Amen.
But 99% of the country is we don't really care. It's going to cost us money, and we're going to override your employer and deny the claim.
Well, the other thing, and again, you're probably, I'm maybe ahead of you, but the quality of care that you get from workers' compensation doctors is not necessarily the top people in the field, and the kind of treatment that you get, maybe just standard of care that they saw on the internet that they don't really understand how RSI should and shouldn't be treated. So even if you get treatment, my question is, what kind of treatment are you getting? Is it what
Well,
you
if you file a claim and you find that the provider is not providing the medical care that you want and you want to switch providers, at least in New Jersey, you file a motion, you get an opinion from the doctor you want to go to, or the doctor who wants to refer you to another doctor who's a specialist, and you file a motion to get that doctor authorized. And,
Oh, I didn't know that. This is great information.
and then the
Thank you.
insurance company could challenge it. But if it's the right thing to do and it sounds right and evidentially, they don't have much of a choice. So you really have to have guidance on this so you can go do it other than scream at the insurance company. They're really not your friends. They're going to call you in to a sense of false security. They'll run the statute on you if they can. They'll do anything they can not to pay the case out for the majority of times because it's a question of that body of money that they have to invest in something else. They know that they have to pay some claims. And it's not as raw as that because judges could impose penalties if it's really outrageous what the employers do or the insurance companies do, but they're usually walking that gray line. So as long as they're walking that gray line between what's reasonable and what's not, they'll get away with it. Plus, they're bouncing this up in the air, and the insurance companies are in no rush to dispose of the case. And if you're in the process, you have to go by the old saying that it's going to take why does it take so long to litigate claims? Because of the rigmarole that's set up through the procedural cottage industry of workers' compensation that has grown out of proportion. So it's not how long, it's how much. And you have to get all the ends tied properly so that if this case is disposed of, you don't end up with another problem down the road with another insurance company or with Medicare, CMS, Centers for Medicare and Medicaid Services, unauthorized medical treatment going forward in the future. Because these things don't go away.
No, they don't go away. And not to derail you, and I can ask this again afterward, but one of the other problems about treatment is that doctors don't want to deal with workers' comp.
Well,
Sometimes they'll tell you that, but a lot of times they just sort of say, "Oh, yeah, go see
they may
someone."
not be a contracted physician with the insurance company. They decided not to deal with that insurance company, or they decide not to do that work. They didn't want the administrative hassle with it.
Exactly. They're drowning in
Doctors like
paperwork. They've got to
privately.
go to hearings.
They
I
go
think
like
they have.
private. It doesn't fit into the normal. It's easier. You can go get concierge doctors. Why doctors bail out? Why they burn out? They have administrative hassles. They have to deal with huge proportion of their business, if they take Medicare claims, is dealing with a major bureaucracy. This isn't the one person in the cubicle. These are mounds of contractors out there which have coding software that track everything and check trends to make sure that that doctor is not over treating or doing treatment that's not authorized. And their surveillance and their auditing is just incredible. So, and there's the scale for Medicare payments, just Medicaid care payments just keeps changing. So you can see what's happening with prescription drugs now, just negotiation on this front overall. That's going to be a big problem. I don't know how the workers' compensation industry is going to do with it because they don't have the body of support. They don't have the grassroots support of one large entity. They're dealing with 50 small entities. And so they don't have the clout that CMS has, nor do they have the backing of the federal government and through legislation to do it. Let's go on to the next slide because I think this is important. If you do have an accident at work and you do have a manifestation of pain, as Deborah said, wherever this pain may be, you need to notice your employer and you need to put them on notice that you have a pain and you have an accident, an occupational exposure. If you went to your family doctor or other doctor and they say, this is from playing with the keyboard or using the mouse or sitting inappropriately or moving your arms in repetitive position all day or checking people out at the cash register and scanning stuff all day, then you need to go and let your employer know this. And you shouldn't delay in doing it. It's not, I'm going to do it later. It's a holiday. I'm going to do it. No, you do it right away. Because if you don't do it right away, you may miss the time to do it. There's notice requirements and there's filing of claim requirements that are time-based. They're jurisdictional. So you need to touch base with an expert in the field who does this legally, probably a lawyer in your jurisdiction, and don't delay. There's plenty of ways to get there. We'll get to how we can pick them out later on. So your case usually has to be filed within a specific period of time. And some states will recognize occupational disease claims and others will not. So you need to contact an expert. So let's go to the next slide.
Oh,
There's
one thing though, when you're if you don't file a claim, it's my understanding that the insurance company will notice, aha, this is upper extremity, aha, this should be workers' comp. And they'll pitch it. If you try to see your private insurer, a lot of times they're going to say, no, 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 this is work related. So the private insurers are pitted against the workers' comp because they don't want to pay for it. So they're saying, hey, and it's really,
It's a
you know, I
whodunit. So it's whodunit. So as a result of that, it's whodunit. They're pointing the finger at each other. So what you have to do is you really need an that it was related to your work, and get it in writing. Say, gee, can you put that on a note for me? Could you type that out on a note for me so I could bring it to my employer? Keep a copy and then note who you gave it to and told. Because the physician that you saw isn't going to get paid if it's work related. So they're going to have to report it back to the work comp carrier and go through a bunch of hurdles themselves, even if it's a denied claim. So you do have, as Deborah said, you do have competing interests on who is responsible. I found two groups that I can confirm are have expertise in workers' compensation. The College of Workers' Compensation lawyers are both adjudicators, lawyers, and judges. They have a directory online. You have to be in the field for 20 years. There are to become a fellow of the college, which was established under the auspices of the American Bar Association like a decade and a half ago, has standards to be met in order to be a member. So you can count on them as having people having expertise. And when you go to the directory, make sure you pick out a claimant's lawyer in your jurisdiction. Then there's another group out there, which is a pay for play group. This is an offshoot of the American Trial Lawyers Association, which is under another name now. But they formed another group called the Workplace Injury Law and Advocacy Group. And you pay your dues, you become a member, you pay more dues, you become a board member. They have a list in there of people who are members, and they do exclusively workers' compensation work for claimants. So there's two routes. You could always ask a friend, you could ask the union rep who he or she suggests. You can ask a neighbor who has a similar problem. So there's options for you. You should get somebody who is familiar with, and don't be afraid to ask, occupational disease claims, because not everybody wants to get involved with occupational disease claims because they're a little bit more complicated than normal claims, accident, traumatic claims. So you have to do your homework and do it early. And don't sit around and say, I'll do it after the holidays, which is everybody does, or don't do it on Friday afternoon at 5 o'clock when you think now's the time. I didn't do it all week. No, do it as soon as you have the accident. The first thing you should do is see your doctor, get a confirmation that it happened at work, notice your employer, and then go find a lawyer. And after you find a lawyer, the communication should go through your lawyer and not through you, so you don't have to battle the insurance company.
And what if you're not happy with your lawyer, Jon? Should we, is it
Most people
possible
are
that
happy with their lawyers. The
well,
question,
I'm not talking about people who are just angry in general and blaming everybody else, but if you feel your lawyer is not competent, because RSI is complicated. It's kind of like asbestos. You have to know a lot about the injury and understand it in order to argue for the
right?
client, I would think.
It's the
So it's,
same thing.
you're looking for someone skilled and
You need somebody skilled.
yeah.
You know, interview the lawyers. It's your option. It's not going to cost you anything to interview you. They probably can't charge for an interview. They're only charged it's contingent basis, and the fees in New Jersey are set by the judges of compensation. It can't exceed 20% of the recovery. It's between 7.5% and 13% if it's a judgment that the judge splits the fees on. So what you need to do is do your homework and interview. You can interview a few lawyers. Call them up. Do a FaceTime with them. Speak to them and get a feel as to how long have they been doing this? How long do they think it'll take? What's their expertise in occupational disease? Did they ever handle this member of the body before? Have they taken any cases up on appeal on it? Have they done any lectures on it? Have they written on it? What do they know about it? Can they suggest medical experts for you, or are they going to send you out to go hunting for the experts?
I'm
It's
so
yours.
happy you're on this live stream because we can just transcribe this and put it in a little PDF and give it to people. I'll put your name on it. You're the one who dreamed it up, and we can have it as a handout for anybody who needs help with workers' comp. This is genius. But I interrupted you. Go ahead, Jon.
So it's your job to do that. If you're complaining now that your lawyer is lousy, then you haven't done your homework. And you should find out if that lawyer is going to handle the case or is he going to give it to somebody else in the office who's been there 3.5 weeks. Okay. Just out of law school. It's your job to do this. Get a commitment from them. Okay. Put it in writing if you want. You're going to handle the case. You're going to go to court with me. Go to the next slide, please, because I just want to go over this. One thing to wrap up. Is there a better way for a benefit program? We are dealing with this workers' compensation system over 100 years old. It's like riding a Model T Ford on a interstate highway now. It just doesn't function. The European countries have left us. They all have a universal medical payer system, so you don't have to go through this problem fighting for medical care. It's provided, and the quality of care in the United States rated pretty low compared to other countries. I'm not suggesting that you move out, but it's interesting to think about. So looking towards a universal medical system is not a bad way to look at this, because then it doesn't matter whether it happens at work or not at work. You're going to get the medical care. And you need a better unified, defined disability benefit program, similar to Social Security. But you need it so it's coordinated throughout the country so you don't get all these offsets and reverse offsets. One of the craziest things are that there were some states that got a free pass in, I guess it was 1980 or someplace back there, which is called a reverse offset, where the workers' compensation system gets the credit for what Social Security is paying.
Could you define offset for me, for
An
us?
offset is the amount of money that they're going to take out of your award. Suppose you receive an award equal to $100, and it could be offset by medical payments made by a major medical carrier. It could be by a private temporary disability carrier that needs to be reimbursed. It could be this ultimate wrongdoer. It could be CMS. It could be a pension fund. There may be some reason to offset it. So you should, the thing is not really coordinated right. So it's a very stumbling way of doing it. And you can't leave these strings unattached when the case is resolved. All of it has to be figured out. Even if it is not hitting you in the face at the moment that case is disposed of, you should ask your lawyer, are all the loose ends covered? Am I going to have a problem with my major medical carrier for an arthritic problem I have in my back? Am I going to have a problem with CMS down the road for a problem I have ongoing with my neck? Are they going to blame it all on this repetitive motion trauma injury? What kind of deal can you make with CMS, an agreement, so that this is not covered and this is not one of the ICD codes that's going to light up on the screen? Another system to do it would be to set up an alternate disputes resolution system where all of these would come out of litigation and save you time, effort, and money, instead of lugging yourself to court for hearings all the time. You may be able to get it into a process where they have an arbitrator or a mediator as an alternate disputes resolution system where this could be adjudicated instead of using the formal system. So there's a lot of opportunities out there. Is it going to happen? It's very difficult when you have Congress that can't move, and where you have states that are entrenched, and where you have insurance companies who are interested in one thing, and that is taking premium dollars. And you have a whole cottage industry of people associated with workers' compensation, whether they be durable supply, good suppliers, or medical providers of giving physical therapy. So it's very difficult to coordinate And that is why it is such an albatross on injured workers. All right. Do you have any questions?
Well, I just want to say thank you. Um, this has been so valuable, and I'm going to post it on my channel. I'm also going to put it in my newsletter because, people are, when they're injured, they're panicked, they're not thinking straight, and they need this kind of measured, thoughtful, deep background. By the way, we're getting it from a top expert who's written 3 books on workers' compensation. So we couldn't have had anybody better than I know of to talk about this. So I want to really thank you for, you know, being willing to join this live stream and educate our viewers, both the ones that are here now and the ones that are going to watch in the replay. Um, I encourage people, if you have questions, to drop them in the comments, and I'll see if I can ask John to answer them. He's under no obligation, of course. But and also, if there's anything specific you'd like to follow up on workers' compensation, that might be possible to do another live stream. But at the moment, I'm curious. Do you have anything to add? I mean, this whole thing is just sort of mind blowing, and you've really covered the waterfront.
Well, I hope I've given you an insight and your viewers an insight into the system and how it's operating nationally and what the benefits are and what the pros and the cons are and the requirements are. But you need to consult somebody in your jurisdiction who has knowledge about this. Otherwise, you're out there in the middle of the rowboat without an oar. And I thank you very much for the opportunity of being here.
Yes, well, thank you, John, and thank you, everybody. And I'd like to remind people that we're living in a world where um, nothing much is being done about repetitive strain injury. So there's a petition, and I'm encouraging people to sign this petition. It's gotten signatures from over a dozen countries, so it's global. I mean, it's not like people in India or the Netherlands or Sweden or Portugal aren't having problems just the same way we are in the States. It's a 12-point program that really addresses the way RSI arises and what doctors and we can do about it. So please sign the petition, and I really appreciate it. If you want to promote the petition, share it with your friends, encourage other people that you know to sign it. Even if you're not injured, you may know someone who is. So sign it for them, and also sign it because if we have better tools and working conditions, you may be saving your own hands. So, anyway, there's the petition. I'd like to thank Jon Gelman again for being such a great guest, and we will see you all next time.